You're probably signaling to me all the time, weren't you? And here I was diligently going through it, working on my grammar. Do I have to do the whole thing again, or did we catch that? You want me to start again?
Through the chair. So maybe yes, start again. My apologies, just so that anyone attending virtually can hear. And you did a great job the first time. I'm sure the second will be equally wonderful.
Now that I'm practiced. All right. Here we go. All right. I would like to welcome everyone to the hearing today. The meeting is called to order at 9:32. Today's proceedings are being held as a hybrid meeting by way of in-person attendance and teleconference to hear minor variance applications PLMV 2024-068 and PLMV 2024-069. The Committee of Adjustment is appointed by Council to consider applications for minor variances to the zoning bylaw pursuant to Section 45 of the Planning Act. Pursuant to Section 45(1) of the Planning Act, a minor variance may be granted provided it meets the four tests, namely that the variance meets the general intent of the official plan and zoning bylaw, that it is minor in nature, and that it is desirable for the appropriate development or use of the land, building, or structure. The Planning Act requires that a public hearing be held before a Committee of Adjustment decides whether or not to approve a minor variance. The public hearing serves two purposes. First, to present to the Committee of Adjustment and public the details and background to the application, and second, to receive comments from the public and agencies before a decision is made. As part of a transparent public process, all submissions form part of the public record. Both the Secretary, Treasurer, and myself, as Chair of the committee for today, will be responsible to ensure that all parties and the committee members can hear one another during the hearing. For those attending by teleconference, if at any time you are having difficulties hearing what is being said, please say so, or click the raise hand button or dial *9. We kindly ask that everyone speak slowly and clearly when addressing the committee. If you are of the opinion that holding the hearing as an electronic hearing is likely to cause significant prejudice, we ask that you advise the committee at the earliest opportunity and the matter can be addressed accordingly. Please be advised that any applicant or agent that is in attendance at today's meeting for a specific application may leave the meeting once their application has been considered by the committee. An applicant, agent, or member of the public wishing to address the committee for an application, a specific application, is reminded that presentations may be limited to 10 minutes per person. If you are using a computer or electronic device, please ensure that your microphone is turned on and your audio settings are not muted, unlike the chair. All parties will be verbally acknowledged before being asked to proceed. At this time, I'll ask that anyone who objects to an electronic hearing of a matter in today's agenda or is having difficulty hearing what is being said, please click the raise hand button or dial *9. All right, with no response. The committee will first adopt the agenda for today. Would the Secretary Treasurer please read the resolution?
Hey, Mr. Chair, that was even better the second time, I can assure you. If I can just get a mover and a seconder for the resolution. Moved by John Aggett, seconded by Jean Neville. Be it resolved that the Committee of Adjustment hereby approves the agenda of the December 9th, 2024 meeting as circulated.
All those in favor? That is carried. Do any of the committee members have a pecuniary interest in any of the applications being heard today? Yes, Jean.
I have a conflict of interest with item 5. It's come to my attention that my son will be doing Mr. Schwartz's build if it's approved.
Let's see. Well, lucky him, or hopefully lucky him. If you could then step out during that part of the meeting.
Yep. Sorry, through you, Mr. Chair, we missed the approval of the minutes.
Didn't we? Didn't we vote and carry? Oh.
With agenda, yes, but minutes we've missed.
Okay. Well, okay. Just reading through the thing.
My apologies.
Not at all. All right, we'll do the minutes next. There are minutes to approve from August 26th and October 28th of this year. Does the committee have any comments or questions about the minutes that have been circulated? Yes.
Just a quick note, spelling error of my name. on the first set of minutes, item 4.
Sorry, through the chair, can you let me know what page that was? I thought we had caught all of that.
August 26, item 4, 2 Ls.
Thank you.
Right. Are there any other adjustments thought of? No, we're all good. All right, then, if the secretary treasurer could please read the resolution.
Through you, Mr. Chair, if I can just get a mover and a seconder. Be it resolved, moved by John Aggett, seconded by Henri Tall. Be it resolved that the Committee of Adjustment hereby approves the meeting minutes of the August 26, 2024 and October 28th, 2024 meetings as amended.
All those in favor? All right. That is carried. All right, now to item 4. Jean? You have yeah, okay. All right. I now declare this to be a public hearing for application PLMV 2024068, located in part of Lot 12, Concession 14, Geographic Township of Snowden. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application? Over to
Good
you.
morning, members of the committee and the public. I'm Michelle, a junior planner with DM Wills, acting as a township planning consultant on behalf of the township of Minden Hills. This minor variance application is in the name of Jacqueline Hill and Jason Schwartz. As stated, the property is located at Part Lot 12, Concession 14, in the geographic township of Snowden and municipally addressed as 1345 Shaw's Lane. The property is approximately 0.4 acres with 134.5 feet of shoreline frontage on the southern shoreline of Canning Lake. The site is accessed via Shaw's Lane, which bisects the property from west to east. It is developed in the form of a cottage, attached deck, and a porch, and there is a boathouse and a dock on the shoreline to the north of the parcel. On the township official plan, the property is designated as waterfront on Schedule A. In the township zoning bylaw, the property is zoned shoreline residential (SR) on Schedule 11. Please note that the site plan that was submitted for review was initially received by the township July 19, 2024 for building permit review. Please also note that the front yard is the water yard, being the distance from the existing building and structure to the shoreline of Canning Lake. The relief that is being sought for is from the required high water mark, which is 30 meters. So as existing, the dwelling is located within the required setback from Canning Lake, making the building legal non-compliant. The application is seeking relief from section 4.8 VI of the township zoning bylaw in order to permit an increase in the size of a building or structure which is located wholly or in part within 15 meters of the high water mark of Canning Lake. Whereas an increase in the size or height is otherwise not permitted in the high water mark. So as proposed, the applicant is proposing to construct a 22.30 square meter enclosed addition to the existing cottage. So under the 4 tests of the Planning Act, the first test is the application minor in nature. So the application of the approval of the variance will permit an increase in the floor area by approximately 10%, which is below the 25% maximum permitted total lot coverage for non-compliant building. While it is recognized that portions of the deck and existing cottage are located within the high water mark, the addition itself is located 16.3 meters from the high water mark, which is outside of the 15 meters, and it will not further reduce setbacks to the shoreline, which are already deficient. The impact of the shoreline has already been established and it would not contribute to or create a new disruption to the area. The application is therefore found to be minor in nature. The second test is if the application for the appropriate development or use of the land or structure. The test of appropriate and desirable development is also a consideration of broader public and planning interests. In this case, it would be considered to be the protection of the shoreline and water quality of Canning Lake. As the proposed addition to the cottage is a recreation-based residential shoreline use, and this is permitted and in keeping with the character of the surrounding area of Canning Lake. The proposed addition will be outside of the high water mark setback and maintain the existing trees, vegetation on the property. The mature vegetation established at the shoreline should mitigate impacts on the shoreline character, provided that this vegetation is maintained in accordance with the county's shoreline preservation bylaw. The shoreline addition is not anticipated to negatively affect the condition of the lake, its hydrological function, or the surrounding natural shoreline area. Therefore, this application is found to be desirable for the appropriate use of the property. The third test is if the application maintains the general intent purpose of the official plan. The township official plan permits recreation-based residential shoreline development in the form of single detached dwellings and the waterfront designation. Policies for recreation-based residential development encourage the balance of built and natural form. Canning Lake is not recognized as being at capacity or moderately sensitive on Schedule B of the township official plan. Policies of the official plan protect the shoreline in its natural state to maintain the area's unique character, and it restricts development that will exceed lake capacity. Generally, development and site alteration must have a minimum shoreline setback of 30 meters from the high water mark of lakes and rivers. However, the township zoning bylaw recognizes the development as a permitted non-complying structure and implements setbacks through the zoning. The application is therefore considered to maintain the general intent and purpose of the official plan. The fourth test is if the application upholds the general intent and purpose of the zoning bylaw. The township zoning bylaw permits the use of single detached and semi-detached dwellings in the shoreline residential designation or zone. As previously noted, it is considered to be legal non-complying due to a portion of it being located within the high water setback. The proposed addition will result in an increase in the GFA by approximately 22.3 square meters or by 10%, which is below the maximum permitted. No new deficiency will be created, and the proposed addition will maintain the existing yard setbacks, and it will not conflict with or increase the extent of non-compliance. The application is therefore considered to maintain the general intent and purpose of the zoning bylaw. At this time, no public or agency comments were received, and it is recommended that the variance is granted subject to the conditions. Does anyone have any questions regarding the application?
Yes, is the applicant or property owner here today?
Yes, sir. I have both Mr. DiCarlo here as our representative and Jason Schwartz, I'm here by video.
All right, thank you for that. Is there any additional information that you would like to present to the committee?
Only that it's an extension to the dining room because it's too tight the way it is, and that's really all it is. And it's going back towards the front of the cottage as opposed to towards the shoreline. And I want to thank planning for their support on this.
For that. Is there any other members of the public here who would like to make a comment, or anyone online who would like to make a comment? All right. Does the committee have any questions of the planner or the persons who have made presentations? Yes, go ahead.
Two quick questions. Was wondering if we had heard from Hydro One. The reason I'm asking is that the hydro line looks a lot closer than is in the drawing.
It's actually not.
Through the chair, we have not received any comments from HydroLink.
And I guess my second question was, when I went on the 5th, I didn't see a sign about the Committee of Adjustment. I assumed it was just covered with the snow, but didn't know if anybody had noticed the sign.
The sign is posted just outside the gate when you're facing the property on the right side, right at the gate. I noticed it myself actually yesterday morning with my wife when we were walking in.
Thank you very much. I must not have seen it for the snow. Thank you.
And through the chair to clarify, so staff did post it, posted the notice. We posted notice at the property as well as at the entrance from the public highway to the private road.
Are there any other comments from any other members or many members of the public? All right. If there are no further comments, could one of the committee members please summarize how you feel about this application?
Through the chair. So yes, if any member of the committee wishes to provide reasons why the application would, or as the case may be, not be supported, then we will consider that towards the decision.
I think as was said, the addition is away from the lake, from the front end, and really has no effect on neighbors as well, because it's on the side where the neighbors aren't.
Not to lead you, but it's minor in nature.
Yeah.
Yeah. Okay. All right. Let's see. Would the Secretary Treasurer please read the proposed conditions for the minor variance?
Through the chair, yes, I can do that. Sorry. First I was like, I'm not sure I have them for me, but I do. So the first one is just that the increase in size of the building would be permitted, which is what's being requested. The second being that the minor variance will only relate to the proposed addition, so it would not permit any further variances. That construction would proceed substantially in accordance with those plans that have been submitted, which are part of the report, and that a building permit be applied for within 24 months of approval of the application to the building department, and that failing any part of the foregoing conditions, that the application would be otherwise refused.
All right, are there any questions from the committee about those conditions? All right. Would the Secretary Treasurer, having heard all the evidence before it, the committee ready to make a decision? Seems so. Very good. Would the Secretary Treasurer please read the resolution?
So through the chair, just so that the committee is aware, what I've included as reasons is that the addition will be away from the lake and that there will be no impact on the waterway. That sums up sort of what. Okay.
That sounds good.
Okay. And I just need a mover and a seconder then.
All right.
And I'll just read the.
Yes.
Yeah, sorry. Moved by John Agate, seconded by Henri Tall. Whereas the Committee of Adjustment considered the oral submissions relating to application PLMV 2024-068 Hill and Schwartz made at the hearing. And whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area, and is minor in nature, and more specifically for the following reasons: that the addition will be away from the lake and that there will be no impact on the waterway. Now, therefore, it is the decision of the committee that application PLMV 2024-068 requesting relief from the requirements of bylaw 06-10 is amended to permit the following from section 4.8.46, nope, 7, sorry. Nope, 6. I have to remember my Roman numerals. To permit an increase in the size or height of a building or structure which is located wholly or in part within 15 meters of the high water mark, whereas an increase in the size or height is otherwise not permitted, subject to the following conditions: that an increase in size of a building located in part within 15 meters of the high water mark of Canning Lake will be permitted for the property located at Part Lot 12, Concession 14, Part 4 to 6 of Reference Plan 19R7921, being part of road allowance and having roll number 4616042000100910 on Shaw's Road. That approval of the minor variance shall only relate to the proposed addition, which shall comply with all other applicable law. That construction shall proceed substantially in accordance with the plan submitted to the township on July 19th, 2024, initially received by the township for building review and put before the committee on December 9th, 2024, and forming part of this decision. That the building permit be applied for within 24 months of the approval of this application following submission of the building department of the appropriate application fees and any supporting information is deemed to be required by the chief building official. And finally, that failing any part of the foregoing conditions, this application shall deem to be refused.
Right, thank you, Amanda. All those in favor? That is carried.
I want to thank the committee for their support on this matter as well. And wish everybody a Merry Christmas.
Yes, and Merry Christmas and good luck with your construction.
Thank you, sir. Bye-bye.
Thank you.
Would the Secretary Treasurer please advise the applicant and the public of the next steps?
Through the chair. So as the application has been approved, there will be a notice of decision released outlining the conditions as well as an appeal period. Following the appeal period, the property owner and or applicants will be able to proceed with the conditions of the minor variance in order to submit for building permit.
Great, thank you. I now declare this matter to be concluded. John, would you mind getting? Got to stretch. Yes. I now declare this to be a public, I never turn that on. I now declare this to be a public hearing for application PLMV 2024-069, located in Part Lot 20, Concession A, Geographic Township of Minden. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application? Over to you, Michelle.
Hi again, this is Michelle from Dean Wills. This minor variance application is in the name of Jean Marie Barker and David Archer. The property is located at Part Lot 20, Concession A in the Geographic Township of Minden, and it is municipally addressed as 1378 Bob Cajun Road. The property is approximately 36 acres with 540 feet of frontage on the south side of Plantation Road. The site is accessed via Bob Cajun Road from the western lot boundary. It is currently being used as a permanent residence for the applicants/owners since October 2023. It is developed in the form of a dwelling, a deck, and a gazebo. The township official plan, Schedule A, designates the property as rural. On the township zoning bylaw, Schedule 7, it is zoned rural RU. As existing, the dwelling is located within the required water setback of the pond feature located to the south of the dwelling, and it is considered to be legal non-complying in accordance with Section 4.34 of the Township Zoning Bylaw. Please note that a garage and additional dwelling unit are currently being erected under separate approval. The applicant is seeking relief from Section 4.84.4 of the Township Zoning Bylaw in order to permit a ground floor area increase of over 25%, whereas an increase in the ground floor area of a building or structure or an area of a septic tile field by greater than 25% is not permitted. According to the application, the applicant is proposing to remove the add-on kitchen and develop the existing deck in order to enlarge the kitchen footprint. They will construct a 44.59 square meter two-story addition consisting of a 13.29 square meter side porch and a 23.78 square meter dining room / sunroom. Under the 4 tests of the Planning Act, the first test is if the application is minor in nature. The approval of the variance will serve to improve the overall utility of the home as a permanent residence for the owners. Given that the property is heavily forested, the existing development is buffered from both the township roads and the neighboring properties, and that the area proposed for the redevelopment is already disturbed, there are no anticipated impacts to the environment or the surrounding area. As noted, there is a garage and additional dwelling unit also being constructed, so there is no anticipated impacts to exacerbate or create new impact. The application is therefore found to be minor in nature. The second test is if the application is desirable for the appropriate development or use of the land, buildings, or structure. The property has been recreationally used since 1860, and the owners reside on the property as of 2023 permanently. The proposed redevelopment will serve to enlarge the existing building to better serve the owners, and it will occur outside of the high water mark of the pond feature. It is understood that the development is currently located within the high water mark, but the enlargement will retain the existing trees and vegetation and will meet the other required front, side, and rear yard setbacks. It is not anticipated to negatively impact the pond, its hydrological function, or the surrounding natural area. Therefore, the application is found to be desirable for the appropriate use of the property. The third test is if the application maintains the general intent purpose of the official plan. A single detached dwelling is permitted in the rural designation. Policies of the rural designation encourage development to preserve the rural character and open natural landscape of the countryside. On Schedule D of the official plan, there is a secondary aggregate resource located within 1,000 meters of the area of influence from the property. The aggregate deposit is protected from the encroachment of incompatible land uses and development that may be permitted in the area of influence. Development may be permitted if it has been demonstrated that no deposits exist, that future extraction is not hindered, and it addresses issues of public health, public safety, and environmental impact. As the site is already developed and the impact of the abutting potential resource has already been established, any impacts to the potential resource would be negligible. The application is therefore considered to maintain the general intent and purpose of the official plan. The fourth test is if the application upholds the general intent and purpose of the zoning bylaw. The township zoning bylaw permits the use of a single detached dwelling in the rural zone. Policies of the rural zone encourage development to preserve the rural character and open natural landscape of the countryside. As previously noted, the existing buildings are considered to be legal non-complying due to a portion of the existing buildings and structures being located in part within the pond feature's high water mark. While the proposed addition will result in an increase of the ground floor area by approximately 109.53 square meters, or by 107.97%, the total lot coverage will increase by 0.06, which will remain below the 20% maximum total lot coverage permitted in the rural zone. No new deficiency will be created, and the addition will maintain the existing yard setbacks, and it will not conflict with or increase the extent of non-compliance. The application is therefore considered to maintain the general intent and purpose of the zoning bylaw. And at this time, no comments have been received, so it is recommended that the variance be granted subject to the conditions.
Thank you, Michelle. Is the applicant or property owner here today? Yes. Would you come forward, please, and state your name? Yes. please. But you certainly can sit
I can
if you'd
sit.
like, yes.
Okay. My name is Jean Marie Barker. I am the owner, along with my husband. The original house is an 1860 log pioneer home. And it was built as a permanent residence and it was lived in continuously, mostly up until the 1950s. And then it was purchased by two different owners who used it as a recreational property. My husband and I bought it in 2010 and we continued that use. And then we decided to move there last October 23. And so we want to increase the size of this so that it is more appropriate for our use to be there permanently because it is a fairly small structure. And so basically there's a kitchen that's there now. It was added about 50 years after the original structure was built. And so we want to remove that and then replace it with this new two-story addition, which will just it's basically the size of the kitchen plus the east and the north side of the deck. And then we're going to add the additional porch and dining room, sunroom. So I believe it is minor in nature. And that's what I'm requesting this relief.
Thank you. Are there any other members of the public who would like to speak to this application? Here, anyone online? Oh, got no one online. All right. Does the committee have any questions to the applicants or the planner? All right. Could a member of the committee offer their opinion about why this may or may not be approved? I ask this as it assists Amanda with her process. Yes, Chief.
I can see that a house built in those days would be much smaller and probably not meet today's standards of housing, and they probably will improve the structure immensely because I imagine you're gonna do the whole outside as well, so.
Yes, we love it. We want to,
Insulation's probably.
yes,
An
exactly.
issue of a house that vintage, so
Yes.
I think it'll be a positive change.
We love it and we want to maintain the heritage of it. Yeah.
I noted that it was a very large increase in the square footage, but almost negligible impact on the overall property because it's a 15-acre, quite a large piece of property.
Mhm.
So in fact, it's quite a minor change, relatively speaking, and doesn't affect the setbacks. All right, if there's any other comments? No, okay. Would the Secretary Treasurer please read the proposed conditions for the minor variance?
Yes, just need 1 second to write down all of the comments. Sorry, yes, just one moment. So through you, Mr. Chair, these are again the standard conditions. There's nothing particularly out of the ordinary. So just that the variance to permit the increase greater than 25% will be permitted, that it's specific to the proposed addition and needs to be substantially in accordance with the plans that were submitted to the township and that are part of the report. And that a building permit will be applied for within 24 months to the building department with everything required for that application, and that otherwise failing any of those foregoing conditions, the application would be refused.
All right. Is there any questions about those conditions from the committee members? Oh, all right. Hearing all the evidence before it, is the committee ready to make a decision? All nodding of heads. Would the Secretary Treasurer please read the resolution?
Absolutely. So first, Mr. Chair, I'll just note that what I've written for the reasons that the house as built would not meet today's standard of living, and the addition will improve the house and living situation. That although a large increase in the size of the house is requested, it will not impact the land due to the property size, and that the setbacks are not being impacted. And if I can get a mover in a second. Moved by Jean Neville, seconded by Paul Radals, whereas the Committee of Adjustment considered the oral submissions relating to application PLMV 2024-0659, Barker and Archer made at the hearing. And whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area, and is minor in nature, and more specifically for the following reasons. That the house as built would not meet today's standards of living, and the addition will improve the house and living situation. That although a large increase in size of the house is requested, it will not impact the land due to property size, and that setbacks will not be impacted. Now, therefore, it is the decision of the committee that application PLMV 2024-069, requesting relief from the requirements of bylaw 06-10 as amended to permit the following: from section 4.8.44 to permit an increase in the ground floor area of the building beyond the permitted 25%, whereas an increase in the ground floor area of a building or structure or an area of a septic tile field by greater than 25%, where that increase would be subject to the existing non-compliance, is not permitted, subject to the following conditions: that a ground floor area increase greater than 25% be permitted for the property located at part lot 20 concession A, the geographic township of Minden, being 1378 Bobcaygeon Road. That approval of the minor variance shall only relate to the proposed dwelling addition, and development of which shall comply with all other applicable law. That construction shall proceed substantially in accordance with the plan submitted to the township on October 11th, 2024, and put before the committee on December 9th, 2024, and forming part of this decision. That the building permit be applied for within 24 months of the approval of this application, following submission to the building department of the appropriate application fees, and any supporting information is deemed to be required by the chief building official. That failing any part of the foregoing conditions, this application shall be deemed to be refused.
Thank you, Amanda. All those in favor? That is carried. Would the Secretary Treasurer please advise the applicant and the public of the next steps?
So as the committee has approved the application, there will be a notice of decision that will be issued outlining everything that I just read off. There is an appeal period that will be mentioned on the notice of decision as well. Following that appeal period, then the applicant or property owner will be able to submit for the building permit and any of the conditions required.
All right, I declare this matter to be concluded.
Okay.
Good luck with your construction and welcome to full-time residency.
Yes, we love it up here and we're glad to stay. Can I just ask how long is the appeal period?
Through the chair, the appeal period is 20 days.
20 days. Okay. Thank you very much. So then in January, I should hear. Is that correct?
So through the chair, the notice of decision will be circulated following this meeting, and then you'll have the notice of decision with essentially steps for next.
So yes, 20 days.
20 days from the day. Okay, very well. Thank you. Thank you.
All right. Is there any new business to discuss?
Through the chair. So there was a schedule that was circulated to the committee members for the 2025 Committee of Adjustment meeting. It's the same as usual, where it would be the last Monday of each month, providing we have applications, other than for December, and it would be on December 8th in 2025. So just looking for consensus from the committee that's a good schedule.
Okay, thank you, everyone.
Okay. And I do have a resolution, Mr. Chair, if I can just get a mover and a seconder to approve the schedule.
Sure.
Yeah.
Could we vote on that we agree with the schedule? Everyone agrees? Passed. If there's no other business, we can adjourn.
So through the chair, there's no other new business. There would just be the next meeting. If we receive any applications, which as of right now we have not, but the next meeting would be January 27th, 2025. Now we can adjourn.
Okay.
I just need a mover and a seconder and I'll read the
Yes.
resolution.
Did someone move? Yes, seconder. Thank you. Yep. All those in favor? We're adjourned.
Can I, sorry, Mr. Chair, can I read the resolution with the
Sure.
thing? Moved by Honoree Tall, seconded by G Neville. Be it resolved that the Committee of Adjustment meeting be adjourned at 10:13 a.m. on December 9th, 2024. The committee will reconvene on January 27th, 2025, unless no applications are received, in which case the meeting will be canceled.
Signature.